Good afternoon, ladies and gentlemen. My name is Mark Rollins. I'm an attorney here in Washington, D.C. I practice primarily in the area of criminal law. I'm also licensed in the state of Maryland. And again, my primary area of practice is criminal law. So today we're talking about your child's been picked up by the police, and you've been notified by the police that your child has been picked up. And you've been notified to come to court. So the question is, what's going to first happen? Well, first you're going to meet with a probation officer or a social worker, and they'll have you go upstairs and you'll be interviewed by that probation worker or social worker. Thereafter, there will be a hearing, which is called an initial hearing. If the judge determines that your child needs to be held further, the judge must make a probable cause hearing for this detention hearing. So he has to find probable cause that the offense actually occurred. And then, if he decides to hold your child, he must come up with two factors. The first is that your child is a danger to persons or property. And two, that he will not appear at the next court date. Now, there are several factors that the judge looks at in order to determine whether your child is a flight risk or will not show up to the next hearing. Now, I'm going to just pause out for a minute, and I'm going to show you some of those factors.
Okay, so I just phased out of that main screen, and now I just want to do this visual screen so you can see what the actual factors are to determine whether the child should be held or not. And essentially, this is done by the judicial officer or the judge. And the first question the judge is going to ask himself is, should the child be held to protect other people? And he's going to look at the record of the child's previous offense against others. He's going to look at the previous weapon offenses, if the child has any previous weapon offenses, and the circumstances in the current pending charge, and so whether there's how serious the circumstances are in the pending current charge. And does the pending current charge involve weapons? Now, if there's weapons involved, there's a greater chance the child will be held. Has there been a threat to witnesses? In other words, has the child threatened any witnesses? And lastly, the emotional character and mental conditions of the child in protecting other people. Should the child be held to protect property of others? Has the child destroyed property in the past, and the extent of the property damage that he may have destroyed, or he or she may have destroyed? And the circumstances of the pending charge. Does it include substantial property damage? Now remember, we're looking to protect property of others, so the pending circumstances, do they include substantial property damage? The next factor, should the child be held to protect him or her? This is kind of self-explanatory, but has he involved in illegal substances or substance abuse problems? So if he has a substance abuse problem, the court could look at that and determine whether the child should be held. Abuse of alcohol by the child, and suicidal or tendencies of the child to be self-destructive, have self-destructive behavior. These are all factors the judge will look at in whether the child should be held to protect him or himself. And lastly, should the child be held because he or she won't come back to court? Now, this is kind of self-aware that if he has a history of leaving places and won't stay still, won't stay in the home, then this is one of the factors the court will look at. But the first thing they're going to look at is, does the child live in the metropolitan area? We usually say D.C., but the child may live in Maryland, may live in Virginia. That's considered the metropolitan area, so it's not that far out if you live in the metropolitan area. Length of time in the area. So how long is the child living in this area? And so that's a factor that should be considered in whether the child should be released. Employment and school record of the child. So having his transcript showing that he's got good school attendance, no truancy, that's a good factor. And the record of the child's appearance at school, his prior court hearings, and whether she has absconded for other institutions such as a hospital, shelter homes, etc. So that's going into that last factor, whether the court will look at all of that to determine whether the child has good trust ability to come back, and that will be a factor looking at. So all four of those things that the court's going to look at to determine whether the child is released after the probable cause hearing. Okay, now I'm going to flip back over to the video.
Okay, so I had to pause out of there because you can see that what I just explained to you was quite voluminous. And at this juncture, you want to get an attorney, and do not worry if you're not able to get an attorney for that initial hearing because it's such short notice. But you have the ability now, after the hearing, to go out and look for an attorney. And the reason why I said don't worry for that first hearing is because if you're not able to find an attorney quick enough or fast enough, the court is going to make sure that if your child is going to be held, that the court appoint or the Public Defender Service will represent your child at that hearing. So do not worry and don't go crazy worrying about what's going to happen, because your child will be protected at that hearing. It's one of the functions of the court is to make sure that children are protected, so regardless of fault. So don't fret. But afterward, you need to go out and look for a good attorney to help you through this process, and good luck. And again, you can contact my office. The number and the information is on the screen. We also have invaluable books on our website. Thanks for tuning in. Thanks.